This meeting is brought to order. The first thing that we need to do is to have an approval of the stated agenda.
So moved.
Is there a second?
Second.
All those in favor? Aye. Okay. How about approval of the minutes as they were sent?
Make a motion to approve the minutes as received.
All in favor? Aye. All right, minutes are approved as well. Okay, the one thing on the agenda for today is the request for variance. Mireya Hernandez is the applicant requesting a variance from Article 2, Section 2.4, minimum lot area of the Fairfield County Land Management Ordinance Number 599. The property is located at 101 and 103 Forest Hills Drive, Winsboro, South Carolina, on tax map number 1260407006000. This request was tabled at the August 18th, 2025 meeting. We have staff recommendations that have been emailed and then some additional ones here. Is there anything else that the staff wants to contribute at this time?
I can go read through it. So as mentioned, the applicant wishes to subdivide the current parcel, which consists of 0.58 acres, and create two parcels as reflected on the reference property survey. The proposed subdivision does not meet the requirements for minimum lot areas in the amount of 15,000 square feet for lots in the R1 zoning district as set forth in Article 2, Section 2.4 of the Fairfield County Land Management Ordinance Number 599. The area surrounding the proposed parcel is zoned R1 under both county and city zoning regulations. The area consists of smaller parcels along Forest Hills Circle and Forest Hills Drive. Parcels in this cluster of properties range in size from 0.15 acres to 1 acre and were created prior to the adoption of the current ordinance. Parcels directly adjacent to the subject property have lot sizes of at least 0.25 acres, though a 0.15 acre parcel does exist approximately 522 feet away. In addition, approving the variance would create the smallest parcel in a 500-foot radius. Please note that under South Carolina Code 6-29-800, a variance may only be granted if all of the following conditions are met, which include that the property has extraordinary and exceptional conditions, the conditions don't generally apply to nearby properties, strict application of the ordinance would unreasonably restrict the property's use, and granting the variance would not harm adjacent properties or the public good. Profitability or convenience for the property owner is not sufficient reason for granting a variance. After review by community development staff, it has been determined that not all of the above conditions have been met. As such, the variance should be denied. Back to you, Carrie.
Thank you, Joseph. Okay, applicant presentation.
Hey, my name is Mireya Bustos. I'm by the property in 2008, I think so. When I'm by the property, they have two houses. In one house, and me and my sister-in-law, I have each house have the land. So, I'm expensing in one house, and my sister-in-law expensing in another house. But I need to separate the houses now. It's because I have the petition. We can division the house. When we buy the house, I don't know which one is the terminus for the Winsboro County.
When you bought, I didn't understand that. When you bought the house, what?
No sabía los términos que tenía la casa. El hombre no me los explicó.
She didn't know los términos.
Las condiciones que cómo tenía que
She didn't know
la
any of
casa.
the conditions when she bought the house, like how she could divide the land or any of the city codes. She wasn't aware of them. So now she wants to divide it because we live in one house and then our sister-in-law lives in another house. And they already have like a block of line dividing the property. So we just assume it'll be like convenient to divide it through there.
Any questions from the commissioners?
I guess the question I have, and I apologize, I was not at the last meeting, but if this is denied, then what are their options as property owners? What can they do?
So if the request is denied, then their option would be to appeal to the circuit court. Is that right? Yeah, it would be appeal to the circuit court if it's denied, and go that route. And then the circuit court would make that decision, which could ultimately overturn what the decision is tonight, or confirm it.
But if they don't go to the circuit court, if it's denied, and they choose to keep the property as is, they can still do that, right? They won't be
Absolutely.
losing, they can still keep it as rental property.
If the variance is denied tonight, then they can continue to use the property as it is, no issues, they just won't be able to split it. If she wanted to sell the property, she could still do that, but the sale is not the issue. The issue is the subdividing the lot, right? So if she wanted to sell that property and just decide to sell the entire lot, no problem, I would get approved. But it's the subdivision that's the issue. So there's a few options that she would have.
But if she did decide to sell, she would have to sell the whole .58 acres, right? She wouldn't be able to sell part of it, would she?
That's right, yeah. So the variance is being sought because of the subdivision of the property creating a lot that is smaller than the minimum lot size. So if she decided, if this was denied and she wanted to move forward with the sale, she could do so, but it would have to be for the entire lot, including both homes, and no subdivision of property.
And if for whatever reason they wanted to sell one house but not the other, they wouldn't be able to do that, is that right?
Correct, yeah. So unless there is a way, which I don't think they have enough space to create two lots that meet the minimum lot size.
Yeah, and they could move the house if that was an option. Still move the house.
Yeah, I mean, they could also move the house too. That's another out-of-the-box option, is to move the house, because minimum lot size is 15,000 square feet. So what is 30,000 into square into acres? Just type it in here. Convert 30,000 square feet into acres.
Let me ask the property owner a question while you're looking
go
that
ahead.
up. Do you all desire to have separate properties for tax purposes? Is that what you're trying to achieve? So the two people in the two separate homes pay taxes separately?
That's one of the reasons, and I think the other person wants to sell their house and move somewhere else.
Okay, so to follow back up on your question, Randy, so she would not be able to go ahead and subdivide the property into two lots that meet the minimum lot size, because that is 0.68 acres, and combined she only has 0.58. So if she wanted to move forward with the sale, if the variance is denied, she could, but it would have to be the entire lot, including both homes. If the issue is for property taxes, and they're just selling it because of the property taxes, there's a way to go ahead and go to the tax assessor to request them to split the property taxes without necessarily having to split the property lines. But if the goal is to divest from the asset and sell it, that wouldn't be possible without having to create the additional parcel, or she just sell the entire lot with both homes on it.
I'd like to just play the devil's advocate for a minute and ask a question so I can understand. The property, that both houses have been there before the county changed the ordinances to require more land per parcel, am I correct? Other properties around there have been grandfathered in with smaller lot sizes because they were already small before the ordinance took effect.
Correct?
Yeah, so they were not fortunate enough to fall within that time period, if you will, because this has come up more recently than that. When was the ordinance approved? Do you know?
The ordinance was approved in 2012.
Okay, so quite a time ago.
So if
So before they owned it or anything, okay.
even if they would have requested it prior to 2012, it would have been approved, and, this wouldn't be an issue. So, the ordinance was created in 2012, so that's why a lot of those other properties are like that.
Yes.
So the structure, the property as it is today is non-conforming,
Correct,
right?
correct. But it would have been before the ordinance because the houses have been there a very long time.
I don't know when the other when the other house was built. Looking back at the property records, there's not really any
Okay.
information
Well,
on that.
looking at the property, it was before 2012.
It appears to be, yes.
I think I can make that a reasonable assumption. All right, so they would have been grandfathered in if they had split it before 2012, so.
Well, the nonconformance of two principal dwellings on the lot, okay, which is also not allowed in the R1 zoning district,
Okay,
was grandfathered in, right? That's why it's a non-conforming.
Good, I hear that, yeah.
So what was not grandfathered in, because it was never requested, is the splitting of the lot,
right.
right?
gotcha,
The division of the
gotcha.
lot.
All
So
right.
by dividing the lot, you are intensifying a non-conforming use, okay?
Yeah,
So the two houses on the lot today, if they were to apply for a permit and say, we want to build two houses, it would be denied. You're only allowed to do one.
and if I may address the applicant, you bought the property and then you tell us that you did not know of the ordinances. It is very important, anytime you buy property, to learn, talk to him and find out what the rules are in a community. And saying that you did not know is not a defense.
No.
Okay. Okay, that's on you. Okay, thank you.
Yes, ma'am.
I want to agree with Ms. Bryant. I totally agree with that, unfortunately. I mean, my heart goes out to the
Yeah.
situation.
Right.
But you also made the statement when the question was asked about the reason for one is separated and one was due to taxes. But you also said that you think the other person wants to sell
Yep.
the house that they live in. I mean, so I'm looking at a financial gain there. If that's my interpretation, that is what you said, right? From your impression that you want to get it divided because that person wants to sell their portion, their house?
They want to sell it for their personal
Yeah, but they
use.
would.
That's
Okay,
fine.
okay. That's why they want to get it divided. Okay.
Are there any precedents in the county for situations like this that you guys know of?
In terms of prior examples?
Yes.
Not that we've done recently, no. Yeah, because when it comes to the variances and things, state law, the one I referenced, the 629-800, is pretty definitive on what it allows. So if there's any concern at all that one of those conditions are not being met, and in our case, there are two in particular that we don't think are being met. One of which is the requirement that strict application of the ordinance would unreasonably restrict the property's use. In our opinion, it wouldn't, because the sale is a financial hardship, not a zoning hardship. So the zoning hardship has only come into play because they want to sell the property. The zoning itself has not restricted the use of the property, not restricted the two homes, not restricted the residential character of the homes, the use of the property. If it was denied, they would still be able to live there, no problems, okay? So we don't think that it meets that one condition. And according to state law, if not all of the conditions are met, the variance should be denied. In addition, financial gain cannot be the primary reason for a variance. So given those two things, that there's a sale involved and that other condition is not being met, that's why we made the recommendation that it should be denied. Since all four of those conditions have to be met. If one of them are not met, then the variance is a denial.
As for me, I agree with your recommendation, and I would stand on denying it.
I just want to make sure I understand this. The financial gain would come from the non-property owner that owns the other house. Isn't that correct? Not the property owner that owns the house.
I don't understand, well,
Well, what he said was the owner of the other house desires to sell. So they would be the ones that would get the financial gain, not the property owner, right? Right,
I thought they were the property owner.
they are, but
Right.
you're
so-
not selling your house, right? The other house is the one that would get sold.
But she owns she owns the lot, though.
Right,
Right, so she owns the lot, and she's saying, I'm selling this portion as the property owner of the lot, she stands to gain financially. Because she's
I
not,
understand what you're saying, but when the other meeting, when they were here, they were written to own. So they have been written to own that house, so they've been written it from you all to own the house. That's how they stated. And so now that they have paid for 9 or 10 years to rent, they have gained money from it because it was a rent-to-own agreement. Now they want to get it split, so this one who did the rent-to-own now wants to sell it. So both of them really have gained money in this when you look at the rent-to-own versus, that's the way I see it.
okay, thank you.
I'm sorry, I did not understand the last thing you said, that they're both going to gain because the couple has already bought the other one, allegedly.
Because the one that was here at the last meeting?
Right.
According to his statement, what he believes, they want to sell too.
Oh, they
So
wanna
that's
sell
why they
also.
want to go ahead and get their
Oh,
part because, yeah,
Yeah,
they want to
because
sell.
last month they said
I
they
know.
wanted to stay.
I know, but yeah.
Okay, so they want to sell
That's
also.
That's what he
Okay.
believes anyway. so.
Okay. May I ask, so both houses, the people want to sell both of the houses?
No, we leave it there with
We
my
want to
family.
live there, but we will both want to live there.
Talk into the mic, please.
We both want to stay there, but in the future, the other house owner might want to sell, and we don't want to leave. So we don't want to sell the whole lot if we have to move.
There seems
they
to be a
decide to.
misunderstanding about who's selling and who's buying and who wants to stay and who doesn't. So you need to be really clear on that point.
Yes, ma'am.
So you're saying nobody intends to sell right now?
Not at the moment,
Is
no.
that right?
Yeah.
Okay.
No, pero le
so
queremos
according to the property records, and this is for the lot, it's Barducio Hernandez Morales and Mireya Hernandez, which are the property owners. Property owner address is 1424 Hutchinson Street, Columbia, South Carolina. That's who's the property owner listed of record.
Well, if everyone wanted to sell at the same time, you could just sell the whole lot and split the money. So you don't necessarily have to split the two properties if people are selling, so.
Yeah, but we don't intend on selling no time
Dile
soon.
que- pero la razón también es porque las casas están muy viejas y cada quien le quiere invertir a la casa.
Well, at the same time, she's saying the houses are really old and she wants to renovate them, but we want to do it separately.
Yeah, I am fixing the house. She fixing the house. It's not fair the houses together because I spend maybe little more money than her or me more money than her because the houses is very old. They need the AC, change the windows, roof, and clean the land because the 101 is, ¿cómo se dice que no está plano?
The 101 ain't graded,
Yeah.
so it's like on a slope.
We need to make a lot of work there, and the 103 is more flat, so it's because we need the one paper, the value my money here too, so it's because we separate the lands too.
Yeah, so what she had just described, the renovation of the property, rehabilitating it, that would not be prevented at all under the current codes, right? That would be allowed. It's the subdivision of the property, that's the issue. Sale, not a problem. It's the subdivision of the property by creating another parcel with that one particular house, that's the only issue.
And who was the young woman who was here last month?
It's my sister.
And she lives in one of the houses, is that correct?
Yeah, it's in 103.
Okay. And do you live in the other house or in the same house with her?
No, in separate house. She's in the front, I am in the back.
Okay. She had indicated to us that over the years, she has been purchasing the house from you, has been paying you to purchase the house, and that she had now bought the house. It belonged to her. Is that true or not? Is that how it has worked?
Que la rentera anda pagando por años para ser dueña de la casa, si es verdad o no.
Yeah, she pay because I'm pay all the money. And in 2008, I'm paid $7,000. But I'm fixing that house. I'm fixing in the 103 or 101. I'm fixing in the electrical and some windows and doors. So I spend money. So she paying for because she cleaning houses. She paying every month $500 for the materials for iron and spend the money. It's because she pay every month. Me.
Okay. So in your opinion, do you own the house still, or does she now own the house?
Si en tu opinión ella es dueña de la casa o tú eres dueña de la casa.
Ya es dueña porque ya ha invertido en esa casa, ya ha limpiado el terreno.
She says she's the owner of the house. The other lady, the young lady.
Yeah. I am the old house and she's in the front house because she spend money too. Because I'm pay the taxes for the house, and when I'm buying, it's 103 or 101 or 103. It's because that way I'm buying because I think, they have two address, it's two houses. It's because I'm buying with my husband. But never coming here and say, because the man sale no explain me. It's because she needed the house for family. She's a mom single and she had 3 kids. So she needed one house and she don't need to pay the rent all the time, you know? It's because we help her and give you that house. And she work in that house too and need to pay that way. It's because we split the land. But she paid more than me. I had pawn 18 and she had pawn 40 because she paid more than me, so. It's fair. I'm pawn 18 and she fair 2.40 because she very working very hard and she paid more than me. It's not fair for me and I have the acre.
So just to clarify, so the rent-to-own agreement, that's not been recorded. So that's not legally binding. She would only own the property according to the law if this survey is approved, the variance is approved, they move along with the survey, and then a whole brand-new tax number is created for that parcel, is, the title to her name. As of right now, if there were to be an issue in the future that says, I'm the owner, the law is going to say, well, no, you're not. She is, because she owns the property. Right. So take that for what it's worth.
I make a motion that the variance be denied.
So I got a question. So since they bought the property before the ordinance happened, how are they not grandfathered in to be able to split it since they bought it before the
So-
ordinance passed?
They're grandfathered in because they're grandfathered in right now for the two houses being on the lot, okay? But they're trying to create a new property after the ordinance went into effect in 2012. So they're grandfathered in regarding the two principal houses being on the lot, but they would not be for the creation of a new parcel because that's occurring now after the ordinance has been in place since 2012.
But in a
So-
sense, the creation of the ordinance created the problem for them of not being able to divide the property.
Well, yeah, but that problem would never have been a problem if it wasn't for them trying to subdivide it now. So. That's correct, yeah. But since the property is being essentially birthed, is being created right now under the current zoning ordinance, they wouldn't be grandfathered in because it's taking place after 2012. And the property as it is right now is non-conforming because there's two primary dwellings, the two houses on a lot of that size. Right now, that wouldn't be approved, right? So if it was, we were only talking about one house, and she had come here to say, I want to build a second house on the lot, that would be denied. Because the zoning doesn't allow for it. Just like creating the new property wouldn't be allowed because the zoning doesn't allow for it because it's after 2012.
But it's almost like if we permit the variance and the lot is divided, then we get rid of one nonconformity and replace it with a different nonconformity. We're going to no longer have two primary residences on one property.
I mean, you're swapping one non-conformity for
Conformity
another.
for another.
Yeah, it's essentially, yes. And you're gonna have to continue that too. Because then you're setting a precedence now, that if anybody else in the community says, well, I want to do the same thing as her, you don't have legal grounds to deny it. Because they can say, hey, well, you did it for her, you have to do it for me. And that can hold up in court. You know, you can't be wishy-washy on one property and not another, and so it would set a legal precedence.
I'm also still bothered by the fact that two addresses were granted to the property. If the county considered it one property, and it's always been one property, that it's got two different street addresses, I think is interesting.
So they address the structures, not the lot.
And there are several properties in Fairfield County that has mobile homes, houses that have different addresses but on the same parcel, if allowed. So it's nothing.
I have a confusion, please. Please help me with this. Now, I didn't get your name, please, ma'am. Okay, Maria. All right, so this shows that you live in Columbia, but then I was hearing you say that you lived in the other house. So how are your address in Columbia and your address here?
When I sign the papers, I give you my address for the paper coming in the deed coming in the mail. I give you 1424 Hutchinson Street for the lawyer, make it the papers. They send me in my mail.
Okay,
It's
so
because
when
I have
did you
1424.
move up to Winsboro?
Huh?
When did you move from Winsboro
We
to
we buy in 2008 and we have the 10 years.
Okay.
We live in 10 years, I think so.
Oh, I see. But it's got your name is in his address.
No, because my
All
my
right.
brother
So,
Aaron
but you own the
Hernandez.
land and the house, the same, all the land and house? Two houses, okay. Thank you. I just wanted to clarify that.
I'd asked the question earlier about public meeting last month, and you said there were no speakers. Has anybody called and complained about it? I mean, the notice for the meeting went up. Have you had any feedback one way or another on the proposal?
There was a notice for the public hearing for the last meeting. Nobody attended to speak. And since then, I haven't received any calls or emails in regards to the subject matter.
We had a motion made to deny the variance request. Is there a second to that motion?
I second.
Is there any discussion? All in favor of the motion to deny, please say aye.
Aye.
Nay?
Nay.
Nays have it.
What's the count?
I didn't vote. I guess I should. What's that?
All right, I just want to confirm for the record, everyone who is voting no to deny the variance, raise your hand. Okay?
No, wait. To, the vote in favor of the motion was to deny the variance. So
Right, so
everybody
raise your hand if you are in favor of denying the
denying
motion.
the variance.
Denying.
Denying, one vote.
Two.
Raise, two votes. Raise your hand if you're in favor of not approving the motion. Okay. Thank you.
I do understand what Joseph said, that we are setting a precedent.
Right, so just to confirm, the four of you are in favor of approving the variance, correct? Okay.
And just a comment, your statement about setting a precedent that would stand legally notwithstanding, I'm trying to think about this, if the same thing came up again under the same circumstances, I think I would do the same, I would feel the same way about it somewhere else. So, just trying to think as practically as possible and put myself in their shoes. I agree with the comment that ignorance is no excuse, but I guess I feel like there are extenuating circumstances
Right.
that need to be considered here.
Yeah, the issue that's going to arise is when it happens again in the future, and it's not because of a sale, what are we going to do then?
Not because of a sale, but I don't agree that the request is for financial reasons at this point. If there's not intending to be any sale on her part, then she's not trying to do this in order to
She's trying to
gain
sell
more
the
money.
property because she wants to split it.
My thought is, my heart, yes, I want to vote yes, do it. But my heart, that's what my heart say, but I'm not here for about my heart. If that's the case, you wouldn't need a board. I'm here to follow the guidelines. And it's clear, even from me reading myself, not only from the recommendation, but everything that I've studied online and researched about this, because my heart was getting in the way, and I'll be the first to admit that. There is no way I could sit here and vote for this knowing that, number one, like you said, because I can tell you, as for me, this is the way I looked at it. Also, we passed this, which it has passed. I see a piece of property now that has two houses on it and that I know can't be divided. Then I'm gonna go ahead and buy that property, and I'm gonna put somebody in both houses, and I'm gonna let them stay there for a while, rent to own, so I earn some money, I'll say rent to own, and then I'm gonna come, when I go to community development, they say, you can't, but now I can, because we, as the Board of Zoning Appeal, has approved something that I don't feel that we can justify based on the law. But that's just my opinion, and I must say I'm very disappointed because it couldn't get no clearer than what I've already seen.
Yeah, that's the direction that we took, that if you look at state law literally, it would be denied. So if you look at, in the front of the page, the key points to consider, I'll just read through a couple of them. So the variance criteria are controlling, right? So the BZA needs to base this decision only on the statutory criteria in which was reviewed, which includes the hardship, unique conditions, no special privilege, and public welfare. The fact that denial might prevent the owner from selling part of the property is not a legal hardship under South Carolina state law. It is a financial impact, and financial considerations alone are not valid grounds for granting a variance. Okay, so that's one of the conditions. Current use is still permitted. The property is zoned for residential use, and the existing two homes are legally non-conforming and are grandfathered. Even if the variance is denied, the owner can continue to use both homes as they exist, so they are not deprived of all reasonable use of the property. Again, what do you consider reasonable, of course? But 3, subdivision request is an intensification of a non-conforming use. So by trying to subdivide, the owner is asking to create a new, smaller lot that doesn't comply with minimum lot sizes and is in violation of the ordinance. That's not a continuation of the existing use, it's an expansion of a non-conforming use, which most ordinances, including ours, are designed to prevent unless variance criteria are strictly met. And then the last one is the marketability versus the zoning compliance issue. So the fact that a property may be harder to sell without a variance is not a unique condition of the land. And frankly, there's many properties in rural South Carolina that face this issue. So, I mean, it's nothing new. But just wanted to make sure everybody was on the same page.
And I hope everybody understands that laws changes all the time. So just because a law is stated at, when you're born or whatever, and then you can take the guns, okay, gun laws, they can say, no, you can't have any guns on you now. But then if it changed and it said, you don't have the option because I was present when the law was presented at that time, that I can continue doing that. You have to abide by the present law.
And again, I think too, as a representative of this board, we're gonna have to leave our feelings and our emotions outside their door and come in here and follow the law. If we can't do that, then I'm on the wrong board. And it's just no way that I can understand besides emotional how we can support. Well, I didn't support it, but I don't see how this passed. I really don't, and I'm just baffled. Not that it makes any difference.
Well, it seems to me that if we're the Board of Zoning Appeals, variances are what are coming before us, and that's exactly what a variance means. It's something that is against the norm, and we've done that for various reasons.
You passed, it's passed. It's good.
Yeah, I mean, that's correct. So it's done for various reasons, and our job is to look at the ordinance, right, and seeing if it's in compliance, and also to see referencing state law. So that's where our opinion came in, that it's neither, again, this is our opinion, that it's in violation of both our local ordinance and state law. So by approving it, that would be going against state law. Again, you can make an argument that all the conditions are being met, and that our interpretation of the property being, being restricted from use is unreasonable. What's considered reasonable? That's where that gray area comes into play.
Can this decision, this vote be appealed somehow?
If someone from the public wanted to appeal it, yeah, they could. And they would go to the circuit court.
Okay, I fall typically on the side of common sense, and I think that's one of the reasons that you have the appeals board, is that, if something just doesn't seem reasonable, then you make a decision based on that. And to me, this seems common sense. There are smaller parcels of land near this one. There are 2 houses on this piece of property, and there's no damage going to be done to anybody by dividing it. It doesn't seem to be, if no sale is imminent, that the primary reason for dividing the property is making more money off of it. It was for the ownership of the house to be clarified. So, I don't know. That's kind of where I'm at. So, is there any other discussion? Okay, we're adjourned.